One and all. In the connection of the webinar series, today we have the stalwarts and the speakers with us. Martin Jones. He is the senior lecturer in the International Human Rights Law at the University of York. So today's our webinar topic is the Finding Refugees Law, a case study of the protection of the Rohingyas in Act. So now I over to you, our Assistant Professor Dr. Sonali Naran, for give the introduction to our esteemed guest of the today's webinar. Now I over to you, Dr. Sonali, please.
Thank you for joining us, Martin. Martin John is a senior lecturer in international human rights law at the University of York, UK. He practiced as a refugee lawyer in Canada and have been heavily involved in the development of legal aid programs for refugees in the global south. He has served as a consultant to UNHCR and UNOHCR and the African Commission on Human and People's Rights and a number of national governments on human rights and refugee law and policy. And he has collaborated with lawyers, civil society organizations working on refugees issues in India, notably the Migration and Asylum Project of the Arab Trust, and his research examines the role of the law in the protection of refugees on what has been described as the frontiers of the international refugee regime, including in the MENA and Asia region, and the effect of the shrinking of civic space for defenders of refugees and other people on the move. Now, I would like Martin Jones to start his presentation, Finding Refugee Law, a case study of protection of Rohingya in Act. Thank you.
Thank you both, and I'm really pleased to be able to be with you today, even if it's only virtually. As Sonali mentioned, I've done some collaborations with colleagues in India, and I think some of the issues around refugee protection in India, as you know from reading the headlines in recent months around the Supreme Court litigation, for example, are really interesting, and certainly to those of us interested in refugee law, sometimes confusing, to be honest. I will admit a bit of confusion in reading the Supreme Court's learned judgment, but fascinating, and they offer us all sorts of exciting opportunities to think about the law differently. And that's really what I want to do today, not drawing on that collaboration in India, but really looking at some of my other work in other parts of Asia, in a particular part of Asia that I'll introduce to you in a moment. And really, I want to challenge our traditional understandings of what the law is and where it is, for that matter, and how it operates. I say that as somebody who, as Sonali mentioned, was a practicing lawyer for a number of ways, and frankly, adopted as much as anybody else a very traditional view of what the law was, and how the law operated. In short, it operated when I was wearing my gown and appearing in court. And today, I think what I'm going to try and do, one of the things I'm going to try and do, is to push our understanding of what the law is, and to allow that new understanding of what the law is to allow us to be able to locate it and use it productively in places that we would otherwise not expect it to be. So as I said, I'm going to be looking at the case study of the protection of Rohingya in Aceh, but obviously the Rohingya are now in many places, including India, as the Supreme Court judgment revealed. And the broader context, I suppose, of this question of where in the world is refugee law, which is the one I'm proposing to answer, or try to answer, formulate at least a way forward towards an answer in my talk, is that we live in a moment of unprecedented forced migration. Right? We have tens of millions, record numbers of forced migrants, many of whom remain trapped within the countries in which they're displaced, but some of whom also flee to neighboring countries. We have large refugee flows out from Myanmar, part of which I'll be talking about today, but also from a range of other countries, including Syria and Yemen, Venezuela, Ethiopia, and even places like Hong Kong. The list could be a long list, but the United Nations has described the forced migration crisis that we're facing in the world today as unprecedented. I think there's a lot of talk about crisis, and we may problematize perhaps a little bit of that usage. But I think the bottom line is, for those of us concerned about the protection and well-being of individuals who are displaced, I think this is a moment where much action is needed. Now, although I'm going to be talking about my experiences in Indonesia and Aceh, although I'm going to be talking about my work with refugees from Myanmar, the Rohingya, I don't want to make this a problem of somewhere else. I mean, at the front of my mind is always not simply what is going on in the places which are often far away from where I'm living right now, with respect to refugee protection, but what does that mean for here? And so for me, the question is, well, what does this tell me about refugee protection and its gaps here in the United Kingdom? And there are many. And equally for you, for those of you in India, then I would suggest that there's a similar kind of question that we should be keeping at the back of our mind, notwithstanding that we'll be learning a bit about what's going on in the northern tip of Indonesia. The other part of the background to looking for refugee law, particularly as it relates to Rohingya, is this map. It's a map produced by UNHCR. It's a few years old. There's a couple of small differences between this map's date of 2012 and today, but for the purpose of our discussion, they're not material. This map conveniently has colored in green countries that have become party to the Refugee Convention. And you will see from this map that an overwhelming number of states in the world, about 147, have become party to either the Refugee Convention or the protocol. The orange is actually states that are party to only the refugee protocol, like the United States most famously. But the Refugee Convention and its protocol, which is actually a standalone treaty, so states like the United States can actually only sign the protocol, really are seen as the foundations of the international refugee regime that came to be in 1950, 1951, as the institutions and norms that continue to shape the protection of refugees around the world were formed and negotiated. In 1950, the United Nations recreated, out of the ashes of an old refugee organization, I think it's third or fourth iteration of a refugee agency that survives to this day, which is an organization that's familiar to many of you, I'm sure, the United Nations High Commissioner for Refugees, UNHCR, the UN's largest operational agency, an agency with operations and field staff in more than 100 states around the world. I think it's more than 160 states around the world now. But you'll see when it comes to the norms underpinning the refugee regime, the Refugee Convention and the Refugee Protocol, you'll see that there is a zone of red on this map. And I asked the question about where is refugee law, partly because there's not an obvious answer when it comes to this red zone. And you'll see that most of you, certainly if you're in India, are in the middle of that red zone. It's a contiguous swath of states that if I were to begin walking at the shores of the eastern shores of the Mediterranean in Beirut, I could continue to progress with a couple of short boat trips all the way to the waters off of Australia without ever having to pass through a state that wasn't red. This is not just kind of a imaginary travel itinerary for me. This is, in fact, the lived reality of more than half the world's refugees. More than half the world's refugees today reside in a state marked in red on this map. And what that means is that the question, well, where is refugee law, becomes important. Because it's really the question of, well, what does the law have to say about their protection? And as I said before, there's not an obvious answer to that. One of the problems with there not being an obvious answer is that we tend then in these places to seek non-legal solutions, what I have described as a protection spaces approach, a negotiated ad hoc political arrangement to respond to refugees that puts them, the refugees who were negotiating the protection of, at the whims of governments and particular circumstances. So where is the law? Where is refugee law here? And more particularly, where is refugee law in this broad swath of red states. Now, before I go on, and like I said, my case study will not actually be about India, but rather another Asian state, or rather a particular part of another Asian state. I suppose, given the audience of my talk, a word should be said about the particular Indian situation, because you'll recall that India itself isn't a party to the Refugee Convention, and you'll recall that there's an important kind of, albeit probably more complicated than generally assumed, explanation to this. India and the early post-independence administrations of India made a very deliberate, and it's been continued, decision not to become party to the Refugee Convention, and in a sense not to adhere to the international refugee regime, a point that your Supreme Court made a big deal about in its recent judgment that I was speaking about. The slightly more complicated, and you know, the short explanation to this is that the leaders of India looked at both the institution of UNHCR as well as the treaty they were being asked to sign, and saw a Eurocentrism in it, which didn't speak to their needs, or for that matter, their new place in the international order. To put it more directly, UNHCR had no ambition to conduct operations outside of Europe at that moment, which wasn't going to be a lot of help to India. And the Refugee Convention allowed states to define refugee in a Eurocentric way, as refugees coming from Europe, and thereby to exclude refugees displaced elsewhere in the world. Now, I think what Kapoor in her recent piece points out and reminds us of is that, in fact, the leaders of newly independent India had a longer experience with refugee protection, an experience that stretched back to the interwar period. And they're being witness to the different ways that the British Empire, the British imperial agents, treated white and non-white refugees as they fled, particularly during the early years of the Second World War, to India. And so, I think the conventional story about a forward-looking, newly independent India not signing up to the treaty for some very obviously correct but self-interested reasons, I think fails to recognize that there's a longer account, a more direct experience of the discrimination of the then imperial order against particular types of refugees in South Asia that probably as deeply influence them. But in any case, the bigger problem here is kind of, in a sense, the broader critique of human rights law raised by people like Eric Posner. What is that they look around the world now, 70 years later after the Refugee Convention, arguably a similar amount of time since the formation of the international human rights regime, which is of a similar vintage. And they look around and they see that actually there's very little evidence, according to Posner at least, that it's accomplished an awful lot, let alone its objectives. There's little evidence that human rights treaties, and we can replace human rights treaties with refugee treaties for the purposes of our discussion, on the whole have improved the well-being of people or refugees. The reason is that human rights were never as universal as people hoped, and the belief they could be forced upon countries as a matter of international law was shot through with misguided assumptions from the beginning. My point here is that the question about what is refugee law, where is refugee law when we look around the world, is in a sense a question that is being asked in response to a much more kind of pointed way of asking the same question by people like Posner. Posner asked, well, where is human rights law? It's not there, it's not working. It's a project that should be abandoned. I think I would probably distinguish my motives from Posner a bit by saying that I'm asking it more as a friend of refugee protection rather than an enemy, although perhaps Posner would dispute that characterization of him being an enemy of human rights. And to answer this question about refugee law, I want us to go back to pause our argument about human rights law. I want us to go back to an earlier idea put forward by one of the drafters of the Universal Declaration of Human Rights. In fact, it's the woman holding the scroll on your screen, which is, of course, Eleanor Roosevelt. And if Posner's saying, well, where is human rights? I think part of the answer has to lie in the imagination of the drafters of the Universal Declaration. And I think in terms of looking for refugee law, we can draw inspiration from them as well. And so one of the things that Eleanor Roosevelt said about 10 years after the Universal Declaration was adopted by the General Assembly unanimously in 1948, so in 1958, reflecting upon the 10 years, one of the things that stuck with me, and has become actually quite a famous quote from her, is the following. Is this answer to this question of where, after all, the universal human rights begin? In small places close to home, so close and so small that they cannot be seen on any maps of the world, yet they are the world of the individual person. The neighborhood he lives in, the school or college he attends, the factory, farm, or office where he works. Such are the places where every man, woman, and child seeks equal justice, equal opportunity, equal dignity without discrimination. Unless these rights have meaning there, they have little meaning elsewhere. And so what I'm going to suggest to you is that the way forward in terms of answering the question of where is refugee law, where is human rights law, the way forward in relation to that draws inspiration from Eleanor Roosevelt's comments that the way forward and the place that we must begin our work isn't in places like Geneva or New York, but rather much closer to home. And so to foreshadow the story I'm about to tell you, the answer to the question of where is refugee law that I'm going to be proposing is that it's in small places close to home. So I'm going to tell you a story. And it's a story that will begin with, I think, probably the best way to begin a story, which is you'll never believe what happened. Which is a wonderful opening of a story because it makes you curious. It suggests that the story I'm going to tell you isn't what you expect. And in a way, it sets you up as a questioning audience, trying to disprove and disbelieve what I'm about to tell you, which I think will make for a rather lively conversation during and after this presentation. So you'll never believe what happened. What happened is that over the last decade, many thousands, up to 5,000, still a fairly small number, but a big enough number to take note of the tens or hundreds of thousands of Rohingya who are displaced, who are chronically displaced, who are often secondarily displaced, who have fled Myanmar to places like Bangladesh and as you know, India, but have also fled further afield to places like Thailand and increasingly Malaysia. Refugees who have fled what has been recognized by the ICJ as potentially a genocide. It certainly has been labeled as such by the United Nations. You'll never believe what happened. 5,000 of them ended up in a place called Aceh, in the middle of that red zone, where refugee law isn't supposed to exist. And they were protected. They were protected by locals with a very particular understanding of what refugee law meant to them. You won't believe this. So as you know, the Rohingya live in Rakhine or Arakan state, generally, and have over the better part of the last decade in waves of ethnically directed violence, so ethnic cleansing, one might say, being displaced within that state and driven from that state outside of the borders of Myanmar. They are a population that has been excluded from citizenship, that has been subjected to virulent rhetoric by public, including religious leaders within Myanmar, as well as certainly political leaders. They fled most famously to Bangladesh, which is in the midst of a crisis within its camps. You'll have read the headlines recently about fires breaking out in these overcrowded places. And you'll also have read about Bangladesh's attempt to relocate many of these refugees from the area around Cox's Bazar to an island where Bangladesh feels they can be better managed. It's a very controversial move. The arrows on this map tell the story of where the Rohingya travel once they flee, or as they flee, I suppose. And as I said before, generally speaking, Bangladesh isn't seen as the destination, particularly because of the dire living as well as economic situation there for the Rohingya. Rather, they are motivated to take risks and to travel a rather dangerous maritime route further afield to places like Malaysia, where the economy is better, jobs are more plentiful or at least higher paid, and where there is a growing community of fellow Rohingya that can provide them with the connections and support needed to establish themselves. What I want to tell you about is the story of the place circled in red on this map, a particular part of the maritime journeys. Yeah. So every year, beginning around now, a little bit before now, the boats begin as the currents and the winds allow them to. And they begin traveling. And even during the pandemic, that has been the case. And they aim for Malaysia, but often end up getting trapped by the coast guards and navies of Thailand, Malaysia, and Indonesia in that triangle of water at the entrance to the Straits of Malacca, as each state competes with the others to push them back, to tow them back out to sea, to intercept them, at best to resupply them, often not even that, and to keep them in international waters where they're not required to take responsibility for them. And the story I'm telling you is a story about how some local fishermen brought these boats ashore. So as I said, beginning in about 2009, and not just in relation to the Rohingya, but largely in relation to the Rohingya, Achenese fishermen have brought boats like this one, full of Rohingya, who have often been trapped at sea for months in this kind of impossible situation of getting bounced between different countries' territorial waters, have brought them ashore. Brought them ashore in response to the overcrowding, lack of food and water that they face, the lack of proper hygiene and medical assistance. I mean, being at sea for months is grueling on anybody, let alone in overpacked conditions. Brought them ashore in response to the challenges of navigation and, for that matter, survival on the high seas for such a length of time, and obviously in response to the interdiction by coast guards and navy ships. But where's refugee law? Where is refugee law in this situation and in this story, given that what I've already told you about this place, of Aceh, is it's a place where there are few international or national human rights or refugee guarantees. Indonesia is one of those red states. Aceh is one of its northernmost provinces, the northern tip of the island of Sumatra. And Indonesia is not a party to the Refugee Convention, nor does Indonesia have a passed by parliament national law. Now, we can talk about the asterisk that is attached to that statement afterwards if you want, but certainly for the purposes of the arrivals that we're talking about, except the absolutely most recent ones, that is true. I think that's more generally true, but certainly any legal frameworks about refugees in Indonesia are not are executive orders, not legislative acts, and are of recent vintage. So how can I profess to talk about refugee law in this rescue of the Rohingya, of 5,000 Rohingya over the last decade or so by fishermen, when in fact, when we look for the law in the ways that we normally look for the law, we don't find much. In fact, we don't find anything. How can it be that the law has anything to do with these kind of rescues? This is a photograph of one of the rescues, actually during the pandemic in June of last year, the height of the kind of the border closures that were occurring because of the pandemic. This is a scene of Rohingya being brought ashore to the welcome of a local village. So this is a story about the more than 5,000 Rohingya and other refugees. There's some Tamils in there too, and arguably some Iranian refugees that have been rescued by Acehese fishermen and welcomed ashore. Welcomed ashore even during the border closures and xenophobia that struck many of us during the pandemic. Well, I guess one of the things I'm going to suggest to you, and I've flagged this at the start, is rather than asking where is refugee law, maybe we should ask what is refugee law. And I think this question, as I highlighted at the start of my presentation, speaks not just to our questions about refugee protection, but the broader human rights project too. So what is refugee law is also what is human rights law. And the place to begin, I would suggest, is actually with the people who did the rescue. We often have very abstract ideas of where the law is and what it is. And I think that there's an alternate approach that involves asking people themselves why they behaved in a particular way, and to see the extent to which they think that their actions can be explained by legal obligation or by something else. And as this quote from one of the Acehese fishermen, I think suggests, there's something a bit complicated going on that does have something to do with the law when these fishermen set out to rescue the Rohingya. In describing one of the early 2015 rescues, he said, "It was about 6:30 when we brought them from the sea to the beach. It took about 3 hours. We'd never seen such a thing. The sea has its own rule. Whoever falls into trouble in the sea, we must take them into our custody. That was the rules. We made the rules together with the Panglima Laut. The Panglima Laut established the sea kanun. I have been a fisherman for 40 years, and the rule has been already there ever since." There's a lot to unpack in this statement. The first to say is that this was not a this may have been begun as a spontaneous action, but as I would suggest from the decade or so of rescues, as well as this fisherman would suggest from the 3 hours it took to bring the people ashore, these are not necessarily actions that should only be understood as spontaneous. They may begin that way, but they're thought out by the time they get to the shore. They're considered. The people involved have had time to think about it and talk about things. Now, it would be easy to dismiss much of what this fisherman says as, well, this is just the way of the world. What does that have to do with the law, Martin? But if you parse very closely what he's saying, and the larger conversation that this excerpt is taken from, I think, reveals this. What he's talking about is something that I think any of us would recognize as the law. The background to Aceh is that it has long had a contested history as part of Greater Indonesia. The Acehese have had a national project long before the Indonesians. In fact, Aceh for many hundreds of years the 16th and 17th into the 18th and 19th centuries, even into the colonial era, existed as a independent, autonomous sultanate that exerted great sway by virtue of its strategic position at the entrance to the great trading routes through the Straits of Malacca, and has, because of that, certainly in the continued imagination of its inhabitants, kind of a great role to play in the region. The Acehnese have a very strong sense of their role within the region. They describe their place, Aceh, in fact, even in religious terms, as the veranda Mecca. It is the entry point of Islam into the region. It is the last point of departure from the region by Muslims going on the Hajj. And it took its role throughout the period of the Sultanate as protector of the faith within the region very seriously, and was recognized globally as such by, for example, in earlier eras by the Ottoman Turks, as having the equivalent role that the Turks took on for themselves in Southeast Asia. What this fisherman, though, is talking about is a set of rules that you and me would describe as the law of the sea, that was formulated during the Sultanate and was passed on both orally and sometimes in writing through the institution of the Panglima Laut, which is was a government institution during the time of the Sultanate, and now I suppose would be described as a professional association of fishermen. It translates literally as the commanders of the sea. And the idea is that the commanders of the sea set rules that fishermen have to abide by through a complicated structure of commanders of Panglima Laut, but also commanders not just of the sea, but commanders of individual bays and estuaries, Panglima Luk. So it's a dispersed but hierarchical organization that enforces collectively established rules about how fishermen should behave. The laws, certainly of the inland seas of Aceh. And one of the rules that they've established is this rule of rescue, that any creature trapped on the water, a fisherman has an obligation to rescue at punishment, at risk of punishment if they fail in that obligation. And for those of you looking for the bite that makes something the law, the Panglima Laut, as an organization and as individuals, very strictly enforce the rules. They suspend people's fishing privileges. They ban their boat from going to common fishing grounds if there's breaking of the rules. It's an area of study that I think has become that much more popular as we try and understand how to support conservation practices in response to global climate change. So what I would suggest to you is that when you talk, whatever the global view is about refugee law in Indonesia, let alone in a place like Aceh, which is on the fringes of Indonesia, when you talk to the fishermen, and we've talked now to, I think, more than 70 fishermen involved in rescues beginning in 2009 and continuing up until the current year, you get a similar, not identical, but similar pattern. They see their actions as motivated by many things, but amongst those things that govern their behavior is their sense of the local law. A local law that I should say is also recognized as part of the peace treaty made between Aceh and the Indonesian state that quelled the civil war that was going on until the Boxing Day tsunami of recent years, that had as its epicenter, unfortunately, Aceh. And it's also a local law that's recognized explicitly in the national legislative instrument that recognizes the province of Aceh as a special autonomous area within Indonesia. So if you're looking for state authority, then certainly the state has expressed the view that this is a legitimate enumerated source of law and that the Panglima Laut are an enumerated institution of local lawmaking. So going back to Eleanor Roosevelt's comment, and I'm towards the end of my presentation, so I'm hoping to hear your questions and comments in a moment. When we go back to Eleanor Roosevelt's question, or her observation perhaps, I mean, her question is, where do human rights begin? And her observation is that they begin, they exist, they have the most meaning, and are most necessary in small places close to home. When we adopt this approach and we go to places like Aceh and we ask not, where is the Refugee Convention, where is UNHCR in this, but rather, why do you do this? What are the rules and the norms that you're following to explain why you do this? We get different answers. And I would suggest that the answers that we get by actually talking to the people are important answers. And I would suggest more important answers than the ones that we get from our global level look at what treaties being signed or not signed. They're answers that I think that are in keeping with a broader shift of how we understand human rights from that globalized regime to more local, process-oriented understanding of actors, the so-called human rights defenders of the world. And my suggestion is, and again, I'm trying to bring together my observations about finding refugee law with broader implications for the Human Rights Project. My point here is that we really have to understand these fishermen as the kind of archetypal human rights defenders, as local actors bringing to bear on their problems local norms, local processes, and local institutions in order to allow, in this case, the Rohingya to enjoy the basic contours of human dignity, and in this case, even their very survival. Now, what does this mean? Well, it means that I think there's a way forward out of the depressing red zone where the law and lawyers, for that matter, can't do anything. It's a way forward that adopts a broad context-specific understanding of what, where, and I suppose how refugee law is and it operates. Refugee law is not simply the Refugee Convention. It is kind of a broader law of asylum that is cobbled together from various norms that are meaningful to local people and that govern their behaviors. It's a way forward that allows for action other than simply insisting repeatedly on the adoption of international norms and processes and an international response. The solution to refugees in Aceh is recognizing and working within that particular legal framework, their understanding of their obligations, and making sure they understand how their obligations as operated under the Adat Laut, or Hukum Adat Laut, the customary law of the sea, align with international refugee law. It is a way forward that responds to the anti-colonial critiques like those voiced by not just the early, but the more recent leadership of India. It responds to these anti-colonial critiques by refocusing discourses on local norms, actors, and processes. It recognizes the agency and contribution of local actors, including lawyers. Now, the fishermen clearly weren't, but they had allies within government that were, and that used this legal construction that I presented to you to defend the fishermen against prosecution and other kinds of interference with their livelihood that otherwise would have been inflicted by the national government that was very unhappy with what the fishermen were doing. And then finally, it's a way forward that provides a more sustainable response to refugees that are rooted within local experiences, values, and histories. So with that, thank you for your patience and for listening to me share my experience. I'm very interested to hear your comments and respond to any questions. Thank you.
Thank you, Martin, for such a good presentation. I would like to ask you, what do you think? How far UNHCR is successful in protecting the rights of the refugees? And as we do not have any definition on the contested or undefined term of climate refugees, how they are going to being excluded in the whole this refugee law. So I would like you to throw some light on it.
Um, I mean, I suppose UNHCR would probably say that the way that we understand rights, certainly at the global level, would never make UNHCR responsible for the rights, let alone of refugees, but for that matter, for of climate, the climate displaced. I mean, UNHCR's kind of main point in this regard is that it's not a state, and that states are the duty bearers when it comes to human rights, and that UNHCR's job, therefore, is simply to, in a sense, facilitate and encourage to support the adoption by states of their obligations, the fulfillment of their obligations. I suppose I think that's an overly semantic way of responding to the concern that motivates your question. I think the concern that motivates your question is how successful have we as an international community been in responding to the needs of people who are displaced because of climate change or extreme climatic events? And the short answer to that, obviously, is really bad, really poor. We've done a bad job. We're not doing any better job. And it's hard to see how there's much of a way forward, given that these kind of concerns, well, certainly from afar, haven't struck me as particularly central to the ongoing discussion of climate change within the international community. I dare say at the upcoming international meeting in Glasgow, I'm not sure that refugees or the displaced are on the agenda. So is it a surprise that we're dealing with them poorly if we're not even talking about them? I'm not so sure that actually understanding, I'm not so sure that the definition is the big problem, and that we haven't recognized them within a definition. I mean, that may be part of a problem, and certainly it may explain part of UNHCR's inaction and part of states' confusion or burden shifting. But I think there's a lot of displaced people who don't fall within a definition. I mean, IDPs in most of the world don't fall within a definition. Many displaced persons internationally don't fall within the definition of refugee, as you know. So I don't adopt it primarily as I don't think it's primarily a definitional problem. I guess what I would say is if we adopt a similar approach to protecting those displaced by climate as we did for refugees, or that I'm suggesting we should for refugees, we need to ask ourselves, in the places to which they're displaced, are there local norms and traditions that we can draw upon, even if the international community is messing up again, in a sense, on this issue? Are there more local, either state laws or customary laws, religious laws that we can draw upon that might better support the welcome and settlement of those displaced persons? And that's where, for me, I think there's more hope. It gives us back agency, even if it's a very difficult job, right? But it does require an intimate knowledge of those local norms and traditions, right? I mean, as a Canadian lawyer, in trying to explain and motivate fishermen to rescue the Rohingya, I'm useless, right? That motivation, that understanding needs to come from within that community, because they're the ones who know that tradition. I mean, until I met the fishermen, which was only after they rescued refugees, I had no idea of the lengthy tradition and its power over them. So we need to really be able to empower and to respect the agency of, I think, very, very local actors who are much more in tune and aware and can be creative about those kind of norms and values.
Okay, thank you. Don't we have any mechanism under which we make states obligatory to accept the refugees or make their condition better in Myanmar, for example? In Myanmar, is is there any international court of justice? There is international court of justice, of course. So don't they make Myanmar to accept to make their condition better and to give them rights? Is there any mechanism or do this matter ever went to International Court of Justice at world level? And if it went, so did Myanmar government is ready to give them rights, or what's that? I mean, I would like you to throw some light on this aspect.
Yeah. I mean, I guess my first observation is I'm not sure that in any circumstance, or certainly not in most circumstances, that the rights in a meaningful kind of way are given mainly predominantly by courts. I mean, I think the history of strategic litigation is that unless there's all sorts of other political, social, economic supports to the claim for rights, whatever a court says, international or otherwise, it doesn't really change things on the ground. So I don't know that the International Court of Justice, for example, can ever be the only solution. But the short answer to that is yes. I mean, the International Court of Justice has been creatively used in this instance. A case was brought against Myanmar alleging a genocide against the Rohingya. And the Court of Justice, I guess about a year ago, determined that there were good grounds for thinking that there was. It didn't issue a final ruling on the issue. But as part of the ongoing litigation between, I think, the Gambia and Myanmar, it issued an interim order demanding basically that Myanmar allow observers and cease particular types of activities that further its, allegedly, and I think correctly, genocidal aims. All of that seems to have become a bit moot in recent months with the coup and kind of the disavowal, really, of what is now a military junta of any real of the international community in any form, even the ICJ, as having any authority over them. So, if you're willing to lock up your elected leaders, suspend parliament, if you're willing to shoot and torture protesters in the street, all against international condemnation, all subject to Human Rights Council and Security Council urgent debates and resolutions, then probably another ruling from the ICJ isn't going to fundamentally change your behavior. So, I mean, the problem with Myanmar is a problem that's not uncommon, right? It's a problem of states that refuse to abide by, either international or even domestic norms. And it would seem, history seems to suggest at least that the way that gets solved, and there's some examples of it, just that kind of behavior kind of fading away and there being a transition to a more normatively compliant kind of behavior. But it's either you face a long period of transition like a place like Chile, or else, like Egypt, you face a violent popular revolution. And it seems that the opposition in Myanmar is hoping for the latter, that they've been through the former already. They spent more than 20 years transitioning from the previous military coup. And they're hoping for kind of a much more, a shorter popular uprising that serves as a counter-revolution and reinstates the elected government. But I suppose time will tell whether that's going to be successful. From afar, and I am very far away from it right now, it doesn't look very hopeful, particularly because the military regime seems willing to use force and violence in quite an appalling way.
Okay, as you have given an example of Aceh, so is there any other example or local communities who are accepting refugees in such a manner, in such a way that they are considering that they need our help and we should help them by going out of the way? So,
I think there's a growing body of work, not just from Asia, where it's kind of motivated by the lack of international and national frameworks, but even from Europe and the West, broadly speaking, including the Americas, that suggests that actually the way forward on refugee protection in many places may be at a much more local level. So there are certainly examples from Europe itself, which generally hasn't had a particularly good record in response to the Syrian crisis, which hit it in 2015 or so. There's a history of local activism at the city level, changing policies and building support for example, resettlement of refugees. So almost all of the resettlement numbers of refugees in Europe, which are now tens of thousands of refugees a year, So, I mean, much higher than they have historically been. Almost all of that has arisen from campaigns at a local level to support cities sponsoring refugees from further afield. That's also, for that matter, the longer history of Canada's own refugee resettlement program, activism at a city level that led to a national policy. So I think there's many examples of local people setting out a local politics that is different from their national politics, often more progressive, certainly more welcoming, and then trying to use that to either carve out a safe space, like a city of sanctuary in the US, or more progressive policies at the national level. Italy has a record of that. There's a lot of kind of city-based activism and regional-based activism that I think has resulted in better policies. And I think part of that is it plays on different levels of identity. I mean, it is, while if I ask you what country you're from, many of you would struggle to say you're from a country where you don't hold the passport of that country. You'd at least recognize a dissonance. If I ask you a more general question of where you're from and you name a place, a city, there's in most cases not going to be any kind of local document or ID or anything. I mean, in York, people say that they're from York, whether they have a British passport or not, and whether they've been here for 6 months or 6 years or 60 years. There is a sense of shared citizenship, membership in a community simply by virtue of physically sharing the same space that isn't tied up quite as clearly in documents or senses of political communities that happens at the national level. So I think there's often a different dynamic at the local level. In the UK, there's a fun, I mean, some people would say it's awful, but I found it quite inspiring. A fun event that happened recently. I mean, it wasn't so fun for the people involved. The Home Office tried to arrest in Glasgow two Indian, if I remember correctly, Indian nationals for deportation. They tried to arrest them on the first day of Eid. In the midst of their community's celebrations. They lived in a predominantly Muslim part of Glasgow. And the Home Office van showed up, they put them in the back, and it was then surrounded by hundreds of locals who refused to leave. And this persisted for 2 days, I think, until finally the Home Office gave up and released the two individuals concerned. So, that's not a particularly legal form of activism, perhaps, but it just shows you kind of how in this case, a neighborhood level, the sense of these people belonging to this neighborhood and the indignity of this happening on such a holy, fortuitous day caused enough people who otherwise probably don't think much about this issue to very physically, put themselves between the van and its egress from the community. They lay down in front of it, they surrounded it in a crowd, they refused to leave. So I'm inspired increasingly by what happens locally. I mean, the difficulty is then scaling that. It is by definition, a local phenomena. And so then, how do we replicate that? How do we make that happen elsewhere? How do we go from 2 to 20 to 200 people whose deportations are stopped? And that, of course, is the challenge.
Thank you very much. Now I conclude the whole presentation. We have started our presentation with the where in the world is refugee law, and the world is facing unprecedented rate of forced migration. And the truth is that human rights law has failed to accomplish its objective, and there is little evidence that human rights treaties on the whole have improved the well-being of the people. And the human rights were never universal as people hoped. In small houses came close to homes, we will find the glimpse of the human rights, how they are being originated and how they are being carried out. And Rohingya refugee Muslims, they fled to Bangladesh, is a destination country, to Thailand, Indonesia, and Malaysia. And we have also discussed the obstacles that Rohingya Muslim face and legal obstacles they face. So Aceh was autonomous body during the colonial era, and they have established the rule of rescue. So then you have suggested a way forward. You have suggested that we should adopt a broad and context specific understanding of what and where refugee law is, and we should allow our action other than insisting on adoption of international law norms and possession. And then you said recognize the agencies and contribution of local actors and put them in change of finding solutions. So thank you very much, Martin, for giving us such a your talk has enlightened us and we have learned a great deal from it. Now I pass to Ramesh Rawat sir for ending this webinar. Thank you very much once again for joining us.
Thank you very much, Dr. Sonali, and connect with me with the Martin. Martin is a wonderful session on the refugee, and I also have some questions in my mind. Maybe these are the general questions, and I have expectations the answer of all these questions. So these are the small questions that the how we can protect the refugees, and what rights does a refugee have, and what are the obligations of a refugee. And one more important question then, can a criminal, war criminal, and a soldier be a refugee? So these are the some small questions. So I have the curiosity in my mind to know the answers from your side.
Do you want me to answer now? Yeah.
Yes, please. Yes, please.
Sure. Yeah. I mean, I think at its core, in a sense, of the question about what rights refugees have, as well as what obligations refugees have, I guess goes back to the question of to what extent we need to recognize the category of refugees and distinguish them from everybody else, right? Because one answer is it's the same as everybody else, right? I mean, one answer is, well, actually, refugees have the same rights as everybody else, and yet, because of that, they have the same obligations. Now, what the Indian Supreme Court would say is, well, actually, that's not completely true, because while they may have similar obligations while they're in India, they don't have the same right as everybody else. And in particular, they don't have the same right of residence that that many other people, certainly citizens, enjoy. And so, any variation in rights and obligations, probably whether it's refugees or victims of trafficking or other kinds of just defined groups that the international community has expressed concern about, any kind of differences in rights and obligations probably stem from that small difference in terms of the rights of residency. And in international law, what the Refugee Convention would say is that the longer a refugee manages to establish themselves in a place and be recognized as having legal status there, the more rights they should get. And that seems a very pragmatic, sensible approach. In terms of who is and who isn't a refugee, I mean, the Refugee Convention itself would say that people where there's serious reasons for believing that they've committed a serious non-political crime, or for that matter, a war crime or crime against humanity, they're not refugees. I mean, I think international human rights law takes a slightly more nuanced approach and says, well, you may not be entitled to various kinds of protections or rights because of that, but you still have some sort of core protection. For example, international human rights law would say that even if you have tortured somebody yourself, so committed a war crime or crime against humanity, for example, you cannot be deported to torture yourself. So you may be torturer, but you will not become tortured. That a state has an obligation not to deport somebody like that, even if they are in colloquial language, kind of a very evil, nasty person. So I think, but I mean, for me at a more local level, in terms of rescuing people at sea, for example, in Aceh, I think there's a range of situations where you don't get a chance to ask those kind of questions, because as the fishermen themselves said, which seems to ring a bell with most of our experiences, when it's a matter of survival of life, everybody has that right, and we have an obligation to rescue everybody. Right? That's what the fisherman said. He didn't get to ask, who are these people? Why are they here? Are they nice people or not nice people? His obligation was triggered by the fact that they were in distress. They were in distress in a very dangerous place, a place that a fisherman knows more than anybody else is a very dangerous place. And so I guess some of the questions around who a refugee is and what they get probably matter more in some contexts, after they've been ashore for many years, or they're wanting to access school, or they're wanting to enter the workforce, matter more than in other contexts. In some contexts, it's just a very simple question of, well, are they humans? I mean, the fisherman actually very interestingly said, we have an obligation to rescue anything that's at sea that doesn't belong there, anything that's alive. And they would phrase their obligation actually not just as another human being. They've rescued animals who have been washed out to shore. And you see this, right? You hear about these elephants or tigers or very large mammals found adrift at sea because they've tried to swim or they've been washed out by a rogue wave or something like that. From the fisherman's point of view, if it's a living animal that doesn't belong in the sea, that's not a fish, their obligation is to rescue it. So it goes beyond even the shared humanity, which is kind of interesting.
Nice. And another thing is what is the temporary and the permanent protection for the refugee, and can refugee request for the resettlement in the specific country, and which country maintain the resettlement quota?
So, I mean, one of the interesting things about Aceh is that the refugees don't really want to stay there. I mean, it's wonderful and they're rescued, but Aceh is one of the poorest provinces in Indonesia, and Indonesia was never the destination of most of the Rohingya. So, I guess it raises the question of, do refugees get to choose where they go? And the short answer is no, right? I mean, so there's no right to resettlement. The way state obligation happens, it happens and it attaches to presence. So you don't have a right necessarily to be taken somewhere else, but you do have rights in the places that you're at. In terms of practice, UNHCR calls it the strategic use of resettlement. And what they say is that they find it's easier to get states to accept to host refugees if they get other states to promise to resettle at least some of those refugees elsewhere within a certain period of time. And so many Western states, but also a growing number of Southern states do support refugee resettlement. It's in very small numbers. I mean, the biggest destination of resettlement used to be the US, and now even under Biden, it's being cut down significantly. But probably a majority of the world's refugees, which are never more than 200,000 a year, a majority of those probably find new homes in Canada, Australia, and the US together. So, all of the other countries combined probably accounts for about 40%, and those three countries accounts for about 60%, but it's always less than about 1% of refugees. So, if you're a refugee looking for resettlement, the odds are pretty long. You have to be very patient and you have to fall within particular categories that are either desirable to resettlement states or particularly vulnerable in your country of asylum.
Thank you very much, Martin Johns. Thank you very much for your wonderful and master talks on today's webinar topic, Finding Refugee Law and the Case Study of Protection of the Rohingyas in Aceh. It's very nice, wonderful topic, and you enlighten to us, enlighten your participants, enlighten to our students, enlighten to everyone those are connected with us. And we want to see you physically in our university, and when the pandemic is over, then invite you to this webinar platform. Please come and join us physically in our university and interact with our faculty members as well as our students. So thank you very much for this wonderful talk and your master talk, and the fabulous session is conducted for our students. And also thankful to our PU webinar team, technical team. They continuously give the support to us, and they conduct us as kind of the wonderful event without any kind of the technical glitches. And also thank to Dr. Sonalis give the opportunity to me to interact with you, and as well as to invite such wonderful guests on PU webinar platform and interact with the students and the participants. And also thank to the other faculty members. Those are the day-night work to promote this kind of the webinar. So I again thankful to you, and I thank you very much to Martin Johns on behalf of the Parallel University, on behalf of the Parallel University management, on behalf of the Parallel University President sir, and on behalf of the Parallel University Vice Chancellor, and on behalf of the Parallel University Registrar sir. Thank you very much, sir. And we want to see you again and again. and I again see to you on few webinar platform as well as physically in our university. Thank you very much. Thank you. Thank you very much.
Thank you very much.
Na-
Bye-bye.
Namaste. Thank you. Bye.